At the beginning of 2020, Michael Diaz was charged with rape and other sexual abuse against two minor children. Now, this is a guy who was a foster father, and he had an 11-year-old and a 12-year-old girl in his home, and he was accused of sexually assaulting them because one of them, the 12-year-old, disclosed to her biological mother that her foster father had been doing this. They'd been penetrating her vaginally and doing all sorts of other things. And he had been using his cell phone to record and take pictures of some of these activities, as well as to show her images of him having relations with his adult partner. So the police became suspicious and they called him on the phone. They had him meet in a public place and the police placed him under arrest and they took his phone thinking that they were going to search it later. Now what happened is the police held it for 123 days before they actually applied for a warrant. And at a motion to suppress hearing, it came out that the police investigator, the detective who was involved in overseeing this investigation, had a lot of duties. He had a lot of cases, a lot of investigations, and it just took him a really long time to put together this detailed application for a search warrant. And so the basic argument from the defense was that 123 days from the time they seized the phone to the time that they applied for a search warrant was unreasonable. And in the trial court, they won. The trial court judge agreed and said this is an unreasonable delay, even though the compelling government interest in prosecuting child rapists is very strong. A person's privacy interests in their cell phone is even stronger. And so we have these constitutional rights. And as of now, the case precedents in Massachusetts are that there's no bright line test in terms of how many days the police have to ask for a warrant from the time they seize the evidence, but it has to be reasonable. And it's really a case-by-case analysis based on the facts of that given case. So again, the trial court judge agreed with the defense, and the prosecution sought an interlocutory appeal. This went to the appeals court, and then a panel of 3 judges evaluated that case. Now, this was a split decision, but it came out today. And for the majority, Justices Eric Nyman and Robert Toone upheld that suppression. They said that we agree with the trial court order in light of the precedent as it stands now. And the third justice, Sabita Singh, dissented. She argued that the case precedent in Massachusetts did not require the finding that the evidence had to be suppressed. As I read through the majority decision, I got the sense that the 2 justices who wrote the majority opinion didn't necessarily agree with the decision, and they kept saying things like, as it stands now, the case precedent requires X. So it seemed to be an invitation for the Supreme Judicial Court to take this up, and I'm guessing that the prosecution will apply to the Supreme Judicial Court to take the case up, and they probably will. And given the result, I wouldn't be surprised if the SJC overturns this and creates new precedent. I don't know. It'll be interesting to see, but it really weighs on, such an important case, such important allegations and serious allegations on the one hand. And on the other hand, even in the face of serious allegations, we have an obligation as a court system to uphold constitutional rights. And under the Constitution, both the United States and the Massachusetts Constitution, we have certain privacy interests that have to be upheld. So we'll see. Stay tuned, and there might be more to come.